Raleigh County, West Virginia, March 4th, 1903, 9 in the morning. A deed was recorded at the Raleigh County Courthouse in Beckley that morning for 411 acres on the eastern face of Flat Top Mountain, transferring the surface rights from the Chesapeake and Ohio Railway's landholding subsidiary to a private company registered in Delaware. The consideration listed was $1 and other valuable considerations. The land had been assessed for county tax purposes at $62,000. The transfer took 11 minutes to process. Floyd Kane, 34 years old, deputy clerk of the Raleigh County Circuit Court, recorded the deed in the standard format, applied the court seal, collected the recording fee, and filed the deed in the day's transaction log. He had been doing this work since 1896, 7 years of recording every land transaction in Raleigh County: sales, mortgages, liens, easements, mineral right severances, right-of-way grants. He knew the county's land transactions the way a man knows a ledger he has maintained for 7 years. Not just the individual entries, but the patterns. He knew which families were selling, which companies were buying, which sections of the county were under consolidation pressure, and which were stable. He knew the rhythm of Raleigh County's land economy in 1903 the way a musician knows a melody he has been playing for 7 years. Not by deliberate analysis, but by absorption, by the accumulation of daily familiarity with the same material. What he had been absorbing for the past 3 years was a pattern he had not been looking for and could not stop seeing once he had seen it. He had put it in a table. The table was in a notebook in the bottom drawer of his desk, underneath the blank deed forms he restocked every Monday morning. The notebook had been in that drawer since January 1901, when he made the first entry. By March 1903, it had 47 entries. Every one of them followed the same sequence. Every one of them had been preceded by a mine incident report filed with the Raleigh County Coroner's Office within 90 days of the land transfer. But here is what the Chesapeake and Ohio Railway, the Bureau of American Ethnology, and the West Virginia Office of Mines have spent 122 years making sure you never calculate. Raleigh County, in 1903, was in the early stages of the coal extraction expansion that would transform the New River and Kanawha coal fields over the following 2 decades. The county's geology, thick seams of high-quality bituminous coal in the Pocahontas and New River formations, had been known to the railway companies since the 1880s, and the Chesapeake and Ohio's land-holding subsidiary had been systematically acquiring surface and mineral rights across the county through the 1890s. By 1903, the subsidiary held mineral rights on approximately 80% of the county's commercially viable coal territory, and was in the process of leasing those rights to operating companies for development. The county's mine population was growing rapidly, from 4 operating mines in 1895 to 17 by 1903, with 3 more under development. The coroner's office, which had jurisdiction over any death or unusual occurrence in the county's mines, was receiving incident reports at a rate that reflected the expansion of the industry. Floyd Kane processed the deed transfers. He did not process the incident reports. His desk was in the Circuit Court's deed recording office, 2 doors down the corridor from the coroner's office. He was not formally connected to the coroner's operations. But the courthouse was a small building, and courthouse staff talked. And Floyd Kane had been in that building for 7 years, and by 1900 he knew the coroner's deputy, a 53-year-old man named Albert Sheets, who had been handling incident reports since 1892, well enough to have lunch with him on Tuesdays and to understand, in a general way, what kinds of incidents came through the coroner's office and when. The pattern he had noticed did not emerge from the incident reports themselves. It emerged from the timing of the deed transfers that followed them. The first instance had been in October 1900. A mine on the western face of Flat Top Mountain, one of the Chesapeake and Ohio's early operating leases, filed an incident report with the coroner's office on October 14th. Kane had heard about the incident from Albert Sheets at their Tuesday lunch 2 weeks later. An unusual discovery at depth, Sheets had said, the kind of thing that happens in deep mines, nothing more specific. On November 19th, 36 days after the incident report, the Chesapeake and Ohio's land subsidiary filed a deed transferring the surface rights above that mine section to a Delaware company Kane had not seen in the transaction records before. The consideration was $1. The assessed value of the transferred land was $38,000. He noted it in his transaction log, as he noted all transactions. He did not note anything unusual about it. He had seen $1 transfers before. They were standard for transactions between affiliated corporate entities and for transactions where the real consideration was not disclosed. He moved on. The second instance was in February 1901, a different mine on the northern drainage of Beckley Creek. Incident report to the coroner's office, February 8th. Deed transfer to a Delaware company, March 3rd, 23 days later, $1. Assessed value, $44,000. Kane noticed the parallel with the October 1900 transaction. He noted it in his personal notebook, which he had started keeping in January for observations that did not belong in the official transaction log, but that he wanted to preserve. By January 1903, he had 45 instances in the notebook. 2 years of Raleigh County mine incident reports followed, within 90 days by deed transfers of the surface rights above the incident site to Delaware-registered entities at consideration of $1. The incidents were not all the same kind. Some were described by Sheets in general terms as unusual finds at depth, some as structural anomalies requiring shaft closure, some as material encountered during lateral drift expansion that was inconsistent with the formation's geological survey projections. None of the specific incident descriptions had been disclosed to Kane in detail. He had not asked for detail. What he had was the timing. 45 instances, 2 years, the same sequence every time. Incident report. Deed transfer within 90 days. Delaware company, $1. He made a table. He listed the date of each incident report, the mine name, the date of the subsequent deed transfer, the name of the receiving Delaware entity, and the assessed value of the transferred land. He noted, in the rightmost column of the table, what Albert Sheets had told him about the incident, the general characterization, without specific detail, in each case where Sheets had mentioned it at their Tuesday lunches. The table revealed something the individual entries had not. The assessed values of the transferred lands were not random. They were concentrated in a specific range, between $30,000 and $70,000, with very few transfers above or below that range. The transfers below $30,000 were for small parcels adjacent to the main incident sites, buffer land, acquired after the primary transfer. The transfers above $70,000 were absent from the table entirely. Whatever was triggering the incident reports and the subsequent transfers, it was triggering them in mine sections of a specific size and production profile. Small mines did not produce the pattern. Large mines did not produce the pattern. Mid-sized operations in a specific geological zone produced the pattern. The geological zone he could identify from the deed descriptions. The table's entries clustered in the formations along the eastern face of Flat Top Mountain and the northern drainage of Beckley Creek, the specific terrain where the Pocahontas seam ran at its deepest, 300 feet or more below the surface. The incidents, whatever they were occurring at depth, in the deepest sections of the county's most productive coal formations. Albert Sheets had been handling incident reports for the Raleigh County coroner since 1892, and in 11 years before the federal inspector's 1901 visit, he had developed a practitioner's understanding of what mine incidents in the New River coal field actually looked like from the coroner's desk. Most were straightforward: gas explosions, roof falls, equipment failures, the machinery of industrial extraction at its most brutal. Some were stranger: the sealed rooms encountered during lateral drift work, the objects pulled from formations that no geological survey had predicted, the chambers that required the company to redirect operations at cost rather than continue drilling. Sheets had learned to recognize the stranger category by the speed of the company's response. A standard accident produced a standard company response: safety review, equipment audit, compensation filing. The stranger incidents produced a different response. The coroner was notified. A federal representative arrived within days. The section was sealed, and the surface rights transferred within weeks. Sheets had seen this pattern 11 times before Kane showed him the table in March 1903. He had not made a table of his own because his instinct, formed in 11 years of handling the county's deaths and incidents, was that making a table of this particular pattern was the kind of activity that would attract the same rapid federal response that the mine incidents themselves attracted. He told Kane to put the notebook somewhere safe, not because he was protecting the county's interests or the railway's interests, but because he had spent 2 years watching federal representatives arrive in Beckley within days of mine incidents, and he understood, from watching, that the apparatus responding to those incidents was not the kind that benefited from documentation. He was 53 years old in 1903, and he had been dealing with sudden death for 11 years, and he understood the difference between a process that wanted a record and a process that did not. The federal response to Raleigh County mine incidents did not want a record. Floyd Kane had been making one for 2 years without knowing that the process he was documenting had already been managing its own absence from the official record for longer than his table had been running. He brought the table to Albert Sheets on a Tuesday in March 1903 and showed him what he had found. Sheets looked at the table for a long time. He asked Kane how long he had been keeping the notebook. Kane said 2 years. Sheets asked if anyone else had seen the notebook. Kane said no. Sheets said he thought Kane should put the notebook in a safe place and not show it to anyone at the courthouse. Kane asked why. Sheets said that the incident reports in the coroner's files from the period Kane had documented contained information that had been flagged for restricted handling by a federal inspector who had visited the coroner's office in the autumn of 1901. He said the federal inspector had reviewed the incident reports from the previous 12 months and had told Sheets that the reports contained material relevant to a federal investigation and should not be discussed outside the coroner's office. He said he had been complying with that instruction for 18 months. Kane asked what kind of federal investigation. Sheets said the inspector had not specified the investigation's subject. He said the inspector had been from the Bureau of American Ethnology, which Sheets had not previously associated with mine incident reports. Kane took the notebook home that evening. He had been living in Beckley since 1899 in a rented house on Neville Street. He put the notebook in a locked strongbox that he kept under the floorboards in the back bedroom, a strongbox his father had given him when he left home for papers he wanted to protect. The notebook went into the strongbox and stayed there. He continued recording deed transfers at the courthouse for another 11 years until 1914, when the circuit court reorganized its administrative structure and Kane was promoted to chief deputy clerk with a broader set of responsibilities that took him out of the deed recording office. By the time he left the deed recording function in 1914, his notebook contained 103 entries. He had continued the table through his entire tenure in the recording office. 103 mine incidents in Raleigh County between 1900 and 1914, each followed within 90 days by a deed transfer to a Delaware entity, each for $1, each covering land above the incident site. The receiving Delaware entities were not all the same company. The table showed 11 distinct Delaware entity names across 103 transactions. But they shared characteristics that Kane had documented in a supplementary column he added to the table in 1905. Each entity had been incorporated within 6 months of its first appearance in the Raleigh County deed records. Each entity had a registered agent in Wilmington, Delaware. Each entity conducted no business in Raleigh County beyond the single deed acquisition that brought it into the county's records. Each entity paid its annual property taxes on the acquired land. Kane had checked this against the county tax records through the same tax agent in Charleston, West Virginia. One tax agent in Charleston, paying annual property taxes on behalf of 11 Delaware entities that collectively held the surface rights above 103 documented mine incident sites in Raleigh County, West Virginia. The tax agent's name was in the county tax records. Kane wrote it in the notebook's supplementary notes section in 1908, when he had confirmed the connection across all 11 entities. He wrote it without comment, the way he wrote everything in the notebook, as a fact, without interpretation, for the record. The tax agent was a 60-year-old attorney named Harold Weston, whose Charleston firm had been handling tax matters for out-of-state landholders in West Virginia since 1885. Weston was not a mystery figure. He was a legitimate attorney in regular practice, listed in the West Virginia Bar Directory, with an office on Capitol Street. He was not hiding his connection to the Delaware entities. His name was on the tax filings as required by law. What was not visible in the tax filings was the name of the person or institution that Weston was acting as agent for, the principal behind the 11 Delaware entities whose tax obligations he was managing. That name was in Weston's client files, which were his professional records and not subject to public access. Weston died in 1921. His law firm dissolved in 1924. His client files passed to a Kanawha County courthouse storage room in 1924 as part of the standard disposition of a dissolved firm's records, where they remained until a records management review in 1952 identified them as having exceeded the statutory retention period and recommended their destruction. The destruction was authorized and carried out. The client files that would have identified the principal behind the 11 Delaware entities holding land above 103 Raleigh County mine incident sites were destroyed in 1952, 29 years after Weston's death, in a routine records management action that no one at the time had any reason to flag as significant. The notebook is not in the courthouse. The notebook went into the strongbox under the floorboards of Floyd Kane's house on Neville Street in Beckley in March 1903, and it stayed in that strongbox through the rest of Kane's career, through his retirement in 1931, through his death in 1944, and through the sale of the Neville Street house by his estate in 1945. The strongbox was in the house when it sold. The buyer was a 31-year-old schoolteacher named Dorothy Hensley, who bought the house with her husband and lived in it until 1963, when she sold it after her husband's death. She had found the strongbox under the floorboards when she and her husband were replacing the back bedroom floor in 1948. It was locked. She had no key. She kept it in the back of the bedroom closet because she did not know what to do with it, and because it was a good quality strongbox and she did not want to force it. When she sold the house in 1963, Dorothy Hensley took the strongbox with her to her new address on Prince Street in Beckley. She died in 1979. The strongbox passed to her son, William Hensley, who found it in the back of his mother's closet when he was clearing her house. He forced it open. Inside was a notebook, a land survey from 1897, 2 personal letters addressed to Floyd Kane, and a folded document that appeared to be a property deed. He kept the contents because they seemed important, and because forcing someone else's strongbox open made him feel obligated to preserve what he found. He did not know who Floyd Kane was. He looked the name up in the Raleigh County courthouse records and found that Floyd Kane had been a deputy clerk at the courthouse from 1896 to 1914. He donated the strongbox contents to the Raleigh County Historical Society in 1981. The 11 Delaware entities in Floyd Kane's table are traceable in the current West Virginia Secretary of State's corporation records through 2 mechanisms. West Virginia requires annual reports from all corporations holding property in the state, regardless of where the corporation is registered, and those annual reports have been filed, in most cases, for the entities in Kane's table from their first year of Raleigh County property ownership through the current filing year. Not all 11 have maintained continuous filing. 3 dissolved in the 1940s, and their property passed through corporate transfers to successor entities. 2 appear to have allowed their West Virginia registration to lapse in the 1970s, but continued paying property taxes through the Charleston tax agent's successors. The remaining 6 have been filing continuously since the dates in Kane's table. Harold Vance traced all 11 in the Secretary of State's database in the summer of 2020 as part of the same research effort that produced his Freedom of Information request to the Smithsonian. The current registered agents for the 6 continuously active entities all traced to a corporate services firm in Wilmington, Delaware, that serves as registered agent for 47 West Virginia landholding LLCs with no commercial activity on file. The corporate services firm's own registered agent in Delaware is a lawyer whose practice specializes in anonymous landholding structures for clients whose identities are protected under attorney-client privilege. The lawyer has been in practice since 1971. The corporate services firm was established in 1969. The entities in Kane's 1903 table predate both by 66 years. The mechanism is the same mechanism. The personnel change. The structure persists. The Raleigh County Historical Society in Beckley holds the contents of Floyd Kane's strongbox in its manuscript collection. The notebook is in the collection, the table is in the notebook. 103 entries dated from October 1900 to October 1914. The sequence, incident report, deed transfer, Delaware entity, $1, is in every entry. The column documenting Albert Sheets' general characterizations of the incidents, where Sheets had mentioned them at Tuesday lunches, is in the right margin. The supplementary notes identifying the single Charleston tax agent as the connection between 11 Delaware entities are in the back of the notebook. The collection is accessible by appointment. The Tartarian framework places this table not as an anomaly in Raleigh County's legal history, but as the financial record of a suppression operation conducted across 103 sites over 14 years. The incident reports that triggered the land transfers, the finds at depth in the deepest sections of the Pocahontas Formation, the structural anomalies, the material inconsistent with geological survey projections, are the physical evidence of the same civilization whose presence was documented in sealed chambers from Fayette County, West Virginia, to Raleigh County, Montana. The deed transfers are not property transactions. They are the financial mechanism by which access to those sites was removed from the commercial extraction economy and placed in the hands of entities whose ownership prevented any subsequent excavation or investigation without institutional authorization. The $1 consideration is the price the suppression architecture paid for each site. 14 years, 103 sites, $103. A Freedom of Information request filed in the spring of 2020 by the independent researcher Harold Vance, requesting all Bureau of American Ethnology field records and correspondence pertaining to Raleigh County, West Virginia, for the period 1899 through 1915, produced a response from the Smithsonian Institution, citing the institution's operational autonomy exemption. The response noted that pre-1940 records were held in physical format and that a comprehensive search could not be guaranteed. It did not acknowledge the federal inspector's 1901 visit to Albert Sheets's office, which is documented only in Sheets's verbal account to Kane, which is documented only in the notebook's supplementary notes section, which has been in the Raleigh County Historical Society since 1981. Floyd Kane, 34 years old, March 4, 1903. He recorded the deed for 411 acres on the eastern face of Flat Top Mountain. Consideration, $1. Assessed value, $62,000. He applied the court seal and collected the recording fee and filed the deed in the day's transaction log, the way he had filed 46 previous transactions in the notebook under his desk. Entry 47. The sequence was the same as the 46 before it. He had been watching this for 2 years. He would watch it for 11 more. 103 entries in a notebook in a strongbox under the floorboards of a house that was sold twice before anyone looked inside. The notebook is in Beckley. The land above 103 mine incident sites is in the hands of 11 Delaware entities whose principal the tax agent's client files would have named and whose client files were destroyed in 1952 in a routine action that no one flagged as significant. The table is in Beckley. The $103 are in the deed records. The 103 incident reports are in the coroner's files, restricted since 1901 by a federal inspector from an ethnological bureau that a mine coroner's deputy had never expected to hear from. The land office clerk who noticed the pattern in the adjacent county to the north, her table covers a different set of transactions in a different 3-year window. It corroborates Kane's table on every structural point. She kept her records in a different place. They survived by a different route. The pattern is the same. The coroner's incident reports that sheets flagged as restricted in 1901 are in the Raleigh County Courthouse Records Archive in Beckley. They have been there since they were filed. The federal inspector's instruction to sheets to handle them as restricted is not in the coroner's files. It was a verbal instruction, not a written one, and sheets complied with it without creating a document that acknowledged the instruction. The files themselves, when examined by any researcher who requests the coroner's incident reports for the period 1899 through 1915, are present and accessible. What they contain is the official record of each incident as reported by the mine operator or the mine's safety officer. Date, location, nature of the incident, disposition. The disposition entries for the incidents in Kane's table are uniformly brief. Site sealed, section closed, matter referred to federal authority. Referred to federal authority. Not resolved. Not investigated. Referred. The federal authority to which they were referred is not named in any disposition entry. The notebook in the Historical Society names it by implication. The Bureau of American Ethnology inspector who visited Sheets's office in 1901 was the federal authority to which 103 Raleigh County mine incidents were referred over 14 years. The Bureau's records of those referrals are in the Smithsonian's Operational Autonomy Archive and are not subject to Freedom of Information disclosure. The coroner's files are in the courthouse and are subject to no such restriction. They are open on weekdays. They have been open since they were filed. The table in the notebook tells you which dates to look for.